Good morning. We are here for oral argument in cause number CV 210590 Alvaro Morado versus Hector Bustamante. These proceedings are being audio and video recorded as well as live streamed. So gentlemen, I ask you to introduce yourself and your client at the beginning of your presentation. Each side will have 20 minutes to present their argument. Appellant, you are responsible for reserving a portion of that time for rebuttal should you choose. We have read the briefs. We've discussed this case in conference. We're familiar with the facts and the arguments. Please bear that in mind during your presentation. At this point, Mr. Abney, if you're ready.
Yes, Your Honor, thank you. May it please the Court, my name is David Abney, and I represent Alvaro Morado. I've been waiting for years to say this in an oral argument, so may the 4th be with you. Star Wars was a work of imagination, a retelling of the hero story, selection, training, preparation, journey, conflict, and resolution. Well, I think that Alvaro Morado and Henry Bustamante ought to be congratulated for coming up with a very imaginative contract. When the roof literally fell in on the residential tenant, Alvaro, he and his friend Henry got together and came up with this 25-year lease notion. So if you put the property back together, you can continue your residential tenancy there, and then at some point when everything's fixed up, you'll be considered a full owner. I don't think they realize it as a matter of law, Arizona law and general law, an owner of a leasehold is the owner of the property for the period of the lease. So he was, once Alvaro undertook to start the residential lease and went forward, he was the owner of the property. So he gets the benefit of the safe harbor under the contractor licensing rules because he did the work to repair the property, basically rebuilt it after the roof literally fell in on him. And got it in such a condition that eventually, about 12 years or so later, he was able to find a subtenant who was willing to what's the right word? Not amend the property, but renovate the property so that it could be turned into a restaurant.
Well, what did the trial court say about that argument?
The trial court said he wasn't an owner because he was simply the leaseholder, that he was not considered to be an owner. And I think that's a mistake of law. Under the restatement, under general principles of property law, under tort law in particular, you're considered to be the owner of the property when you're the leaseholder. You're the occupier and the owner. So he would fall within the statute.
If we reject that argument, let's move on and talk about landlord-tenant law. And it was a leasehold for 25 years.
Yes.
I mean, he wasn't the owner. An owner owns the property in perpetuity. He was basically a lessee with free rent for 25 years, was he not?
Yes, he was a leaseholder, but he was also considered in the eyes of the law to be the owner of the property, and that makes him fit within this safe harbor provision.
The owner-builder exception to the contractor's license. But if we look at this from a different perspective and talk about him being a leaseholder, is there anything in the Landlord-Tenant Act that would protect him for the activities that he undertook?
I don't know if it would or not. I don't think about, and we're not dealing with that, I think.
Oh.
What we're dealing with.
Why aren't we?
Well, we're dealing with the licensing statutes for contractors. And the thing that got him in trouble was Henry died, and then Hector comes along and says, what are you doing to the people who were there? And he says, we're renovating, we're making this, turning this into a restaurant. He says, get out of here. And then Henry says, no, you can't, pardon me, Alvaro says, no, you can't kick me off my leasehold. This is my leasehold. I've done everything I'm supposed to do for this leasehold. It's my property.
Let me maybe kind of take Judge Campbell's question a step further. So we have, on one hand, we have the licensing litigation bar, or the contractor litigation bar. On the other hand, we have the Arizona Landlord-Tenant Act that says that a landlord and tenant may agree to a contract whereby the tenant will perform repairs. Okay? I can't imagine the legislature contemplated that would be only applicable if the tenant is also a contractor. Do you?
No.
Okay, so doesn't that legislation specifically contemplate a situation in which a landlord and tenant would agree that the tenant could perform contractor type work in
Yes.
exchange for rent or forgiveness of rent?
Yes, it does. I don't know if anybody ever thought of it from that perspective in this particular case.
Yeah, it might be that we need some supplemental briefing on this because
Hallelujah. Absolutely. Anything that I could do to find my way out of the swamp that my client landed me in would be helpful. I had simply not looked at it from that angle. I took what I had and went forward to do the best that I could with it, but that's a valid point.
yeah, it's 33, 13, 24C and D, I believe, are the statutes, and Judge Campbell's the one who pointed this out to me. I'm not trying to take her thunder. But it does seem that we have this tension between these two, because you have landlord tenants fully authorized to enter into these types of agreements, and the contractor statute says, but there's a litigation bar. So tell me how we would reconcile those, or tell me that we need to do supplemental briefing.
Well, supplemental briefing would be good on that point, but it'd also be good on the point of which statute controls. Which one would be considered the more specific statute, the one dealing with this particular situation?
Which is, the general rule is the specific governs the general, isn't it?
Specific.
The general rule is the specific governs the general.
Yes. So the specific provision of the Landlord-Tenant Act would govern here, I would think. I'd like to brief it, though, and think it through on paper.
And the problem for you, though, is the Landlord-Tenant Act also has a statute of frauds provision in it as well, which says it has to be in writing.
I like the statute of frauds problem because we have part performance. In fact, we basically have essentially full performance, and he's done what he needed to do. The property's in good condition. Now we can sit on his heels and pull in the money from the subtenant. So he's pretty much done everything he has to do.
Yeah, there's a quantum Merowit type argument there, or unjust enrichment argument
Sure.
that you could pursue, but that would also the benefit of the lease free. That's going to be a whole bunch of factual issues for the trial court to discern.
Well, from Alvaro's perspective, what he had this done. He had done what he had to do. The contract with his friend was already pretty much done, finished, everything's ready, and he's got a subtenant, everything's going to go forward, and all of a sudden the property's taken away. It doesn't really fit within 32-1153. It talks about the contractor may not maintain any action in the court of the state for collection of compensation. And I know that the legal minds here are brilliant enough to say, well, isn't this really compensation? It is and it isn't. It's property by this point. He's already done everything. It's his. He's enjoying it. And the next thing he knows is the people are kicked off, the subtenants are kicked off, and he sues. He's not really suing for traditional compensation. He's not saying to Hector, I want you to pay me money. And what he's saying is, I want my property back. I did everything that I needed to do to earn this property, and it's mine now, and I want it back.
Which brings us back to contracting without a license. You're talking about the specific owner-builder exception. We talk about, and the trial court found that your client wasn't an owner-builder.
Right.
We can agree with that, but let's just, for the purpose of this argument, say we do agree with that. Your client is also a leaseholder.
Correct.
So what I'm trying to kind of get my mind around is this. Conveyance in real estate has to be in writing. Terms longer than a year have to be in writing. All of these writing requirements. We talk about, I just don't understand how you think he qualifies as an owner-builder under the statute as written. Help me get there.
Well, the statute...
Just saying I own something does not make it so.
No.
Okay.
That would be sort of nice, wouldn't it? But
Wouldn't
no.
it?
Well, depending.
Except for the people we were
I like
just
your thought.
working
Be
of their
careful.
benefit, yes.
The trouble with the statute and with this, when I looked at this, I said, owners of the property, okay, was he an owner or not? And yes, under the restatement and under general case law, he'd be considered to be an owner. I don't think the statute has a good definition of what an owner is, or has any definition of what an owner is. So you have to go, what's the common meaning of the word owner? And then you stumble in from that, you go, okay, maybe yes, maybe no for common meaning, but is there a specialized meaning for the word owner under the law? And there happens to be. You can be an owner under the law simply by having a lease. You own the lease, you own the property for the term of the lease. You're considered to be an owner in the eyes of the law. I think if you go step by step to try to figure out what owner means here, you wind up concluding owner can and should mean somebody who has a leasehold.
Well, I mean, we know as lawyers in law school that words can have different meanings in different contexts.
Right.
It just seems odd to say that a leaseholder would be an owner under the contracting statutes.
Well, not really when you think about the historical development of ownership. Under English law, ownership of something was the big thing in life. You own property, you own a leasehold. Look at Jane Austen's wonderful novels. They fret all the time about who owns what and how much. And all that has bled into Arizona common law and then into Arizona statutes. Ownership can be somebody who has a leasehold. You're considered to be an owner in the eyes of the law. And I admit to you, you have to go a step or two to try to understand exactly what the term owner here could and should mean. But it's not a stretch by any means. You simply say, is it defined? No. What is the general meaning? And then you scratch your head a little bit and you go to ARS 1213, I think, that says you generally give words their common meaning unless there's a technical or specialized meaning that may be intended. And here we've got a bit of a specialized meaning.
Well, the young people live in apartments. So do they own their apartment? I mean,
For certain purposes in the eyes of the law, yes, they would be deemed owners of the property, yes.
I don't think that's the common understanding
Right.
of what
Well-
owner means, Mr. Abney, when I talk about ownership versus leasehold. So I lease Judge Howe my property. He builds a mansion on it,
Yes,
incurs all the costs.
yes,
His lease ends. I get his mansion.
you sure do.
So there's a difference.
Well, for the period of time that he was the lessor, he owned the mansion. I'm sure it would be a very nice
for
one.
you.
He had possession of it, but
Yes.
he didn't. There's a difference between owning and leasing. Agree
Yes.
with me?
Yes, there's a difference between fee simple ownership, for instance, and leasing a fee simple holding.
It's been a long time since I property law school, but I always thought of it as you own the leasehold, you don't own the property. And
Well, there was
maybe I need to retake those law school classes.
I don't think you need to do that. But the authorities I cited to the court, especially in the reply brief, have made it very, very clear that if you are the owner of the property then you are, either if you're the occupier of a leasehold, then you own the property for purposes of the law. I mean, we're familiar with the concept that you can have several capacities. Look at corporations. They're citizens, they're residents, they're considered people in certain circumstances. Or look at ourselves. Well, look at the judges on the panel. You're judges, lawyers, citizens, residents. You have all kinds of hats. And in this case, Alvaro Morado had two hats. He was the lessor and considered in the eyes of the law to be the owner of the property. And that gets him into the safe harbor here.
I think to resolve it seems to be heavy weather, though, to figure this out, isn't there? If we look at it through the landlord-tenant lens, would there be an easier way to resolve this?
The Residential Landlord-Tenant Act would be probably the easiest way if we can have the opportunity to work it through. I speak moderately well on my feet, but I think better on paper, and I would relish the opportunity to address that because it just flew right by my head that would apply. I focused in on this contracting stuff.
Who owned the droids back in Star Wars? I always
R2-D2?
Yeah, which one?
I think Princess Leia did, but I don't know. I don't know about
Luke had a
C-3PO.
pretty valid claim to him for a while
He
there.
did have a pretty valid claim.
C-3PO sort of wandered in from nowhere. I'm not quite sure where he came from. But anyway, I have wandered into Star Wars again, and if there's no further questions, I'd reserve some of my remaining time.
Thank you.
Thank you.
Thank you.
Thank you, Mr. Abney. Mr. Evans?
Good morning. It's a pleasure to be back here. I think, my name is Robert Brown. I represent the employees in this case. I think the numerous apartment owners in this town would be shocked to learn that the persons who are renting apartments from them are the owners of the apartments. Clearly, there's a difference. Just because you are possessing an apartment does not mean you own the apartment. And it all comes down to fee title. The person, the entity, or the person, let's just use a person as an example, they don't hold title to the property. And that's because they're leasing it from the owner who does hold title. There's no deed conveying the ownership of the property to the person who's renting the apartment.
What is the purpose of the safe harbor? I mean, I hate to dive too deeply into legislative intent, but what is the purpose of it?
Well, the purpose of it is if you want to screw up doing modifications to your own property, construction work to your own property, you're free to do so. But we don't want you, in contrast, the other statutes, 32-1151 and 1153, we don't want Robert Brown, who's not a licensed contractor, going to Judge Campbell's house and rebuilding her roof, because Robert doesn't know what he's doing. But if Mr. Brown wants to go and rebuild his own roof, even though he doesn't know what he's doing, he's the owner of the property and he's free to do that. So that is what I glean as being the purpose of the statute.
But doesn't the safe harbor, so we have this general rule of, if you do contracting work for fixing Judge Campbell's house and she doesn't pay you, you can't sue her. That's the litigation bar. Right?
If I act in the capacity of an unlicensed contractor, that's correct.
Right. What does the safe harbor then do in that situation if Judge Campbell is the one suing? Is that right? What is the owner exception to the safe harbor? What does it do?
Well, so I'm the owner of a house.
Mm-hmm.
If I want to do modifications to the house, if I want to modify the roof, or I want to install a new bathroom, or I want to redo the tile on the floor, I'm free to do that.
But how does it interact? What I'm trying to understand is we're referring to it, and the briefing refers to it as a safe harbor from the litigation bar. And I don't understand how those two are interacting.
Well, I think you first have to look at the purpose. You have to back up for a second. You have to look at the purpose of 32-1151 and 1153. What's the purpose of those statutes? The purpose of those statutes are to protect the public from Mr. Brown working on their house.
I'm tracking that.
Okay. So, we don't want Mr. Brown working on their house because he's not a licensed contractor. Okay?
Mm-hmm.
And it's a deterrent to keep people who are unscrupulous, unqualified persons, entities from doing contracting work. Because obviously, there could be pretty serious consequences if I get on top of Judge Campbell's roof and I don't know.
Both to you and to Judge Campbell, right?
Yeah, to her.
My roof is fine, just saying.
Yeah, or Judge Hauser.
Well, what if Judge Campbell asked you?
Pardon me?
What if Judge Campbell asked you to fix the roof?
And if I accept it, I run the risk of I could do a bang-up job and I could say, Judge Campbell, could you please pay me? And she'd say, no. And
you can do a poor job and I can go to sue you and I'll be precluded from getting any recovery or assistance from the Registrar of Contractors or having any access to the contractor's recovery fund for victims of unscrupulous licensed contractors.
I
agree with me.
No, I'm not going to agree with you.
I would agree with me.
You can sue me. I
can sue you personally, but I'm limited to your assets, etc.
Pardon me?
I'm limited to recovery from your assets as an individual. I don't get the assistance. The registrar will go after you for unlicensed contracting, but I can't get the recovery fund access, which is the pool of money that the registrar must maintain to compensate people who have contracted with unlicensed contractors, or with licensed contractors who've done unworkmanship kind of quality of work. Which is regardless, and we're going down a rabbit hole.
Yeah,
Who cares anyway?
Yeah, but going back to, I'm sorry, I don't mean to interrupt, but the I can't remember exactly what your question was, but the purpose of the safe harbor provision, so if you look at the purpose of 32-1151, 1153, it sort of tells you what the purpose of the safe harbor provision is. I can get on top of my roof and do a bang-up job and not do a bang-up job, and the person who's harmed is me. It's not you, not Judge Campbell, not Judge Howe, it's me, because I'm the owner of the property.
Right, what I'm trying to understand, and which I'm sure it's just because I'm dense, but I understand how Mr. Abney's argument about the safe harbor interacts with the litigation bar. I'm having a hard time figuring a scenario in which the safe harbor for owners would somehow apply in the litigation bar. I guess you could sue yourself for...
No, of course you can't.
Okay, so then that's what I'm missing is he refers a lot to the safe harbor or the exception to the litigation bar, at least as I understood his argument, from an owner suing or an owner doing the work. Why does it matter whether it's...
Oh, I see. I understand exactly what you're saying. And that is a very good point, because like you said, you can't sue yourself. But no, in 32-1151, 1151 makes it unlawful to act in a capacity as an unlicensed contractor. Now, I'm going to do this off the top of my head. I could be wrong about this, and correct me if I'm wrong. I'm not trying to overstate anything, but there might be a criminal component to that.
And I get the safe harbor allows you to do your own work, maybe insulates you from criminal liability for doing your own work, but I'm still not seeing how they interact with the litigation bar, and that's what I'm hung up on.
Well, it doesn't really, okay, so 32-1153 says, you as a contractor, I do Judge Campbell's roof, I do a bang-up job, she just decides not to pay me, payroll's a little slow at the Court of Appeals, whatever, and I cannot sue her. And even though that's a harsh penalty, and there's Arizona cases that say, this is a harsh penalty, but it's as a public policy, we don't want Mr. Brown working on other people's roofs. Okay? I don't think the safe harbor probably has anything to do with 32-1153 because I can't sue myself. But it probably has something to do with 32-1151.
I'll tell you, I thought I was throwing you a softball, and I feel like I've messed up somehow in the questioning. But my point is, and I'll ask Mr. Abney to respond, he has 6 minutes left to this too. Assuming we don't decide or reach this Landlord-Tenant Act issue, which I want you to address too, but I don't see why it matters whether his client is the owner or not. It's still him trying to sue somebody for work being done. That's your argument, right?
Well, I mean, they admit that he was an unlicensed contractor.
Right.
I mean,
but I'm saying even if we accepted his argument that a lessee can be considered an owner of the property, I don't know why it matters.
Well, the only reason I would say it does matter is because of the safe harbor provision. and I know that goes back to your original point. Well, what's the interplay of the safe harbor provision? But the bottom line is, okay, the point is that the safe harbor provision doesn't apply. I mean, that's the bottom line. I mean, he wasn't the owner of the property. I mean, I don't rent an apartment, but like I said, I think the many apartment owners in this town would be shocked to learn that the persons who are renting apartments from them own the apartments. They have
we understand that argument.
Okay.
I had an aha moment. I finally understand what he's saying. Let me try and break it down for you. So you have the owner-builder exception, which is what Mr. Abney is arguing. If you're an owner and you do the building, the work inures to yourself, and you as the owner would never be suing yourself in such a circumstance, would ya? No. Did I get it? Woo! Took me a minute, sorry.
I agree with everything you just said.
Okay.
Well, let's turn, if we can then, because, I think we may be asking for supplemental briefing, but
I think we will be asking for supplemental briefing.
you tell me, so.
On what issue? I'm
You
sorry.
take my word for it that there is a provision in the Arizona landlord-tenant law that says landlords and tenants can enter into agreements to basically contract, to do improvements, repairs, et cetera. We have the contractor thing that says, no, you can't do it unless you're a licensed contractor. How do those two interact?
Well, you're asking, is there actually a provision in the Landlord-Tenant Act that says that?
I'm
Really
telling you to
there
take
is.
my word for it. So for purposes of our arguments here, you can assume that there is a provision that says that.
Okay.
I can read some of it to you if you'd like.
I would, so obviously that issue, I really would hate to comment about that, I mean, right now. I mean, because we haven't briefed it at all, and I would just be winging it, and I really don't want to wing it.
So let's go to your arguments against applying equity. If we were to agree with Mr. Abney in the abstract that, not saying we do, that the owner-builder exception applies, don't you think it works as a disservice to Mr. Bustamante, who relied on an agreement with the previous owner, your client's father, to do all this work? What should he be compensated for the work he's done on the property already? Or should he just be precluded entirely?
I mean, there are cases, Your Honor, where the courts have said that 32-1153, the purpose of it is to keep unscrupulous, unqualified persons or entities from acting in the capacity of unlicensed contractors, and it can lead to harsh results.
It can lead to harsh results,
Yes.
but you would agree this isn't the typical kind of relationship that statute was adopted to address, which is you come to my door and say, I'd like to repair your roof, and I ask you, do you have a license? And you say no, or you say yes, but you end up not having a license. That's the kind of, I'm going to pay you money, you're going to fix my roof. That's the kind of arm's length transaction that we're talking about, as
Sure.
opposed to this kind of a transaction.
Well, I don't know why this isn't an arm's length transaction.
Well, when we say compensation, compensation can mean a lot of things, but let's assume that in the typical contractor-contractee relationship, compensation is money. That's typically how this occurs.
Okay, but compensation doesn't necessarily have to be money. I mean, he received compensation for having ownership of the property after construction was completed for 25 years. And there's a compensation element to that because then he was allowed to rent out the property, which he attempted to do because there was a person when Hector, I believe it was December of 2019, when he noticed somebody inside the property, the person was setting up a restaurant. Okay, so his client was leasing out the property to somebody who was going to pay them rent. So there is a money component to this. It's not just, ownership for 25 years. Does that address your question?
Nope.
Okay.
When you look at this transaction, this is not a typical transaction between an unlicensed contractor and a property owner.
I would agree with you. I mean, 9 times out of 10, you pay the contractor money to perform work.
Your client's father went and helped Mr. Bustamante get the building permits, etc. Would you agree?
I'm sorry, what's that?
There's evidence in the record that your client's father, the owner of the property at the time the agreement was made, did things like assist in getting building permits, talk about what was going to be done, scope of work-wise, etc. Would you agree?
I don't want to make that admission right now, but let's assume that's true.
Okay. So this isn't the typical, I'm going to hire you kind of thing. Don't you think it would be unfair? And this all goes to equity. Should Mr. Bustamante be precluded from making an argument in equity for the value of the work that he actually did with the acquiescence and agreement of your client's father.
Okay.
Is there any way to compensate him?
Okay.
Don't you think it's a little unfair?
Well, okay, so just to be clear, my client's Bustamante, his client is. I go to your house and I do a bang-up job. It costs me $50,000, and you say, Robert, I'm not going to pay you.
You're living in my house. I say, fix my whatever. You say, I want to put in landscaping, etc. here. And I say, go for it. I'll take it off your rent. You tell me what you spend, I'll take it off your rent. Isn't that more this relationship?
Well, there was nobody living with a roof caved in. It would be kind of hard for somebody to be living in this building. So whether he was actually a tenant is most likely a disputed fact. But let me go back to...
Well, he was living there before the roof collapsed, correct?
I don't think so, Your Honor. My client, no.
At least there's a dispute about it.
There's a dispute. So, but it's a harsh result. But courts recognize that, because we don't want Robert Brown, working on David Abney's house. That's the point. Because I'm not qualified to do so, and we don't want Robert getting paid. It's a deterrent.
So a landlord can't approach a tenant and say, this part of the house is broken. If you fix it, I'll take off your rent, or I'll extend your lease. And in your analysis, that can't be done.
I'm sorry, could you repeat that? I'm sorry.
Sure. If you have a landlord and a tenant, and something in the house breaks, the landlord can't go to the tenant and say, if you fix this, I'll take money off your rent. That can't be done, because that would violate the unlicensed contracting statute.
Well, I would agree with that. But however, there's the Residential Landlord Tenant Act issue. But generally, yes, I would agree with that. And courts, I cite the cases, in my brief. Courts have found this is it is a harsh result for have somebody, I do a bang-up job, but I don't get paid. That's the Arizona legislature has spoken, and that is the deterrent, and that keeps me off the streets from acting as an unlicensed contractor, and that's why.
I'm sure that's the only thing that's keeping you from going out and doing some unlicensed contract.
Well, yeah, but it's no different than a criminal statute. Okay, it's a deterrent. I'm not a criminal attorney, but I guess, homicide or murder, I don't know what the penalty for that is, but it's probably pretty harsh. And, it's a deterrent.
I don't care how good a hitman you are, you can't go and sue to cover your hitman fees either. So.
I'm just talking about, yes, of course, because the contract is illegal, okay. But, and the sort of the same analysis applies in this case. The contract between me and Judge Campbell is illegal. Because I cannot allege and prove that I was a licensed contractor. And it's a deterrent to keep me, I don't know if I keep using myself as an example, but it's just obvious, that I don't do contracting work, to keep me from going around and screwing up other people's buildings, because I don't know what I'm doing. So my time is dwindling down here. So I don't know if you have any other questions.
Nope.
Thank you, Mr. Brown.
Thank you.
Mr. Abney, before you get started, I want you to answer yes or no. Is it true that your client Morado argued below He was only attempting to enforce his rights to possession and control under the residential lease, not to collect payment on the construction contract. Is that basically his argument below?
Yes, I think so.
Okay.
I'd like to take one more try at the interaction between the safe harbor and the litigation bar. The safe harbor is 321121A, subpart 5. But the important part of the statute is really, this chapter does not apply to owners of property who do the work. So if you're an owner of the property and you do the work, the whole chapter doesn't apply to you, including the litigation bar. And I think the litigation bar matters because they're saying, as my colleague said, well, we regard this as compensation. But if the litigation bar doesn't apply because you're an owner, then you can go ahead and do the lawsuit if you were seeking just compensation. So that's the interaction.
Could an could an owner say, I'm going to contract to build my home on my property,
Right.
but I'm going to hire subcontractors via my subcontract, or I'm the contractor overall, but I'm going to hire these people to come in and do subs and do
Right.
certain portions of it. Would the litigation bar apply in that case or not?
If you're talking about the owner wants to sue the subcontractor who's not licensed, I think you apply that ownership definition, if you can apply it to the subcontractor. If he doesn't fit within the owner provision, then you get to sue. You jump over to ARS 32.
Right, so that's my point, is I get your argument that it doesn't apply to owners, but we have the owner here who's suing, so even if there's two owners, we still have two owners suing each other. Why does that bar apply? Well, it does not apply to the owner. So your guy says it doesn't apply to me.
Right.
But we have another owner is the one who's suing.
The owner
Who's being sued is a separate owner.
Well, I don't think it applies there as a defensive. The owner who was suing is Morado. He is suing to get what they say is compensation. What he says is just give me my property back. That's what he's after.
Right, but I don't think there's any dispute that Mr. Bustamante is a legal owner as well.
He is also an owner, yes.
Okay, but he's not the one doing the contracting work, so.
Right, so this doesn't, and actually, this provision 321153 only applies to a contractor who is trying to sue for compensation. So it doesn't apply to Mr. Bustamante at all on that aspect.
I get that argument of your compensation point. I'm probably just too befuddled by the language.
I hope supplemental briefing will help us out here. I do want to mention the Klimkowski case.
She's got a finger up, so you should let her.
I will get back to Klimkowski.
Thanks. All right, Mr. Abney, your client lived in this property as a residential property. This
Right.
isn't a commercial property.
Correct.
It was being converted to a commercial property, and who knows if there was zoning or not. But he was a resident in this building when the roof collapsed.
He was indeed.
And lived there as his home, not his business.
Correct.
Okay, and the record supports that below.
Yes.
That was my understanding.
But your colleague says that's in dispute. Was that in dispute?
I don't think so, because it referred to him in the record as he was a residential tenant. The roof falls in, there's property's damaged, and then they come up with this 25-year thing. And I applaud them. It's a very nice thing to do. Let your friend live there, and you put the building together. And the only bad thing for Henry was he didn't live long enough to get the property back. But, we're all mortal. Anyway, Klimkowski, which says, Arizona courts have adopted the principle that property law regards a lease as equivalent to a sale of the premises for the term of the lease, making the tenant both owner and occupier of the property. So I've got Arizona precedent right on point to go with their statement.
Okay.
And to go to Dobbs on torts. I keep interrupting you, I'm sorry.
No, I keep interrupting you. I'm sorry. You go ahead.
You're allowed to do that. I'm not allowed to go the other way.
When she puts the finger up, though, I would stop.
Yes, I'll stop.
Yeah.
Was there anything else I could attempt?
Don't, go ahead.
Well, I think actually I'm done, unless you want to talk about ownership rights and Star Wars. I thought about C-3PO. I think he was a property of the Empire. He was trying to escape.
Maybe.
But R2-D2, I'm pretty sure was Princess Leia's property.
And I thought C-3PO had been abducted by the sand people in the desert, in the dunes.
He was later, but after he landed on Tatooine, after getting off of the Star Destroyer.
Oh, okay.
Yeah.
He was abducted later on in the saga. All right, Mr. Abney?
I think
any
Mr. Brown
final
wants to
thoughts?
weigh in on Star Wars there, I'm seeing.
I love Star Wars, but actually, I had a substantive question, but that's.
I'll surrender my 1 minute 33 seconds for a substantive question with the court's indulgence.
Absolutely. Mr. Brown, go ahead.
Well, okay. My question was going to be the landlord-tenant provision that,
We've been discussing, yes.
yeah, what, the site, do you mind giving that to me? If you have it readily available.
Well, here's the question. I would like supplemental briefing, and the answer will be in an order contained with the citation of, which you can give it to him right now if you've got it, but the citation and what specifically we want information on.
Sure, yeah.
Do you mind supplemental briefing?
Pardon me?
Do you mind doing some supplemental briefing?
Well, if you want it, I'll provide it.
Wonderful, Mr. Brown.
It is
And I will get an order out directing you to do so.
ARS 33-1324 C and D, I believe, so.
1324
C and D.
C and D. I don't want to abuse any time. I didn't talk about the statute of frauds, and I don't know if you had any questions about that.
I think we're good on that.
We're good on that.
Okay.
Gentlemen, we're going to take this matter under advisement. It has been a rousing discussion of all kinds of definitions, et cetera, and so at this point, we will issue a written order asking for supplemental briefing so you can let us know about the Landlord-Tenant Act. We are at recess.